Okay. Thank you. My name is Natalie Mara. I'm the Executive Director of the Ontario Health Coalition. We're here today because we have taken a major step forward in the Charter Challenge to Bill 7, the euphemistically titled More Beds, Better Care Act. The act neither provides more beds nor does it actually improve care. It actually enables hospitals and placement coordinators to move patients out of hospitals if they're deemed alternate level of care into long-term care homes not of their choosing. So long-term care homes that they don't want to go to, they can be up to 70 kilometers away in southern Ontario, up to 150 kilometers away in northern Ontario, and with the proviso that they could even be further away in northern Ontario if there are no beds available within 150 kilometers. The legislation also enables them to override the consent of patients, so to share their personal health information without their consent, to apply for admission to long-term care homes without their consent, and to admit them into long-term care homes that they don't want to go to without their consent. All of this under threat that if they don't do it, they will be charged $400 per day for their hospital bed. Bill 7 overrides patients' fundamental human rights, their right to privacy and informed consent, their right to be treated equally to other patients, their right to be safe and secure, and to have their lives protected. So we have undertaken this charter challenge because of just how profoundly egregious the legislation is. And how concerned we are for the well-being and the safety of the patients whose lives are at stake. And this will be thousands of patients over time that are put in this situation. Before I turn it over to the lawyers, I'll just say that we are hearing from patients who are being affected by Bill 7 now. And this is what we're hearing. We're hearing from people who have loved ones who are in hospitals who have aggressive behaviors, who are unsafe in certain long-term care homes, unsafe for other residents and unsafe for themselves. And yet our attempts are being made to force them out to long-term care homes that do not have behavioral supports and are not safe for their loved ones to go to. No one would like, is one of the last things that happens in their mom's or their dad's life, that they hurt someone or kill someone or profoundly hurt themselves in a violent fit of behavior in a facility that can't take care of them. And the families are trying to get them into facilities that are able to actually take care of them. We've heard from people who are in hospitals who've been told that they have to shortlist only the long-term care homes that no one wants to go to in their areas, only the long-term care homes that have the shortest wait lists. That is not true, but they're told that, and therefore then they can only end up going to those homes that no one wants to go to. We've heard from patients who are deemed alternate level of care to be discharged to long-term care, but the long-term care homes they apply to will not accept them because they say that they cannot provide the level of care that patient needs. And so they end up in a limbo with the hospital trying to force them out and no one wanting to take them. I think this underlines just how inhumane this policy is, that it is about trying to clear out hospital beds. Ontario has the fewest hospital beds left of any province in Canada by far, after decades of downsizing our hospitals beyond any reason and evidence. And it has put patients into this position where the government is far behind on building its long-term care homes. There are models of what could be done to solve these problems, and Bill 7 does none of them. We need more hospital beds. There is no question in Ontario. We need to reopen closed hospital capacity. We need more long-term care beds. And we have a model that the Ford government actually did of fast-tracking 4 long-term care homes built on hospital properties. They were built within 18 months to 2 years. They're up and running. Why we're not doing more of that, or we haven't done more of that in the last couple of years, given the wait lists, is inexcusable. And we need improved home and community care. So with that, I'm going to turn it over to Jane Meadus. Jane is a lawyer and institutional advocate at the Advocacy Center for the Elderly. And I should just finish by saying, so we filed the notice of application with the court yesterday. We filed expert testimony from 5 expert witnesses in addition to the plaintiffs, the appellants, and they include really some of the foremost experts in geriatric care, palliative care, health policy, hospitals, and long-term care in the country, and a very strong, we think, case to move forward with. And this is Jane Meadus.
Hi. So I do work for the Advocacy Center for the Elderly, which is the other applicant in this case. I'm the institutional advocate. I've been a lawyer there for 28 years, and I deal almost exclusively with people who are in long-term care homes and hospitals, specifically with respect to discharge. What we're finding, the calls that we're getting in our office now are certainly people who are very, very fearful about what is going to happen. It's generally families or loved ones that are calling on behalf of very sick, incapable elderly people who often aren't able to speak up for themselves because of dementia or other issues. They are being threatened with this $400 a day, being told that if they don't choose certain homes that they're going to be charged, which isn't actually true. It's only if you get a bed offer in a home that is on your list and you turn it down, that they can charge you. But there's a lot of pressure on people in hospital to be moved into homes that they don't want. These homes are often far away. They often are physically substandard homes, so these are homes that have not kept up with modern design standards. People go in and report to us that they are dingy, there's nothing going on, they smell, all sorts of issues in those homes. They're generally often homes as well that have poor compliance histories. And the ministry has really not done a good job in ensuring that homes rebuilt. Most of those homes were supposed to be rebuilt by 2020. They didn't do that. We're still looking at homes being rebuilt. And of course, we're now hearing about homes that are being closed because they'd rather build condos. But the homes that have the beds, really are these homes that are either in places that people are too far away from where people would want to live, or have, other issues in those homes. We don't have hospitals pressuring people to go into homes that are, homes that are, everybody else wants to go into. One of the problems is that the system is controlled by the Home and Community Care Support Services, which is supposed to have been, sort of an independent place where they can, ensure that people's rights are upheld. And of course, they're the people that are being tasked with trampling over those rights when a person doesn't choose the homes they want or doesn't consent to the homes that they think they should because they should be on short lists. They're the ones that are controlling not only which homes get chosen, but also they control those lists. So people are told, as Natalie said, that they can't apply to the homes that they want to, not even to put those homes that are most desirable on their list. And they're also the ones that control the crisis list. So even though they should be crisis for those more desirable homes, they're told not to apply to them. And of course, we have no idea how home and community care support services are actually placing people in those crisis lists because there is no specific rules around that. There's some guidelines, but there's no specific rules. So it's not a transparent system. People are being told, of course, that don't worry, this is just temporary. You go in there and then you can always transfer. And really the transfer is the myth. If the person breaks down and decides to choose a home, what they're finding is they get there and they discover that the waiting list, they're way down on the waiting list. They're not a crisis to transfer. And so they're never going to be moved. And we've had people being told, like, you're just never moving, so don't even worry about it. And that's not what they're told when they're being asked to put these places on a list. Even people who go in where they're not consenting, where the HCCSS is doing the choices, they are on that crisis list, but they're still going to be lower on the crisis list. As I said, it's not transparent, so they're not going to be the person that's going to be chosen. It's going to be those people who are in the hospital that are going to go in. We've had consent to choose long-term care, and generally this is a place where you're going to die. You're going to probably go and spend the rest of your life there. We've had specific legislation since 1995 around that consent, and before that, less so in legislation, more by common law. As well, we've enshrined the release of personal health information. We have personal health information that now can be sent to any home without your consent. It could be to homes where you maybe have family members you don't want to see your records. You could be part of the LGBTQ plus community and have your records being sent to homes where perhaps they're not as LGBTQ friendly. We do have a lot of religious homes or in areas that may not be as supportive of those communities. We're going to have people outed, and that's always been a big problem. And we're also having problems in that these people who are in hospital are not getting the services that they should be getting. And so they get, designated as ALC and they get warehoused. They are put in diapers. They're not toileted. They're not put in wheelchairs. They're not getting proper services. They're being denied rehab. And when they get to long-term care, they discover those services aren't there either. So it really is a dire situation. People are getting forced into places they don't want to live. And that really can't provide that care. And, this bill is, contravenes the charter and should be stopped.
Thanks, Jane. And we have Stephen Schreiman, who's our lawyer representing us in the Charter Challenge from Goldblatt Partners.
Good morning. As Natalie indicated, we filed an application with the Superior Court of Justice yesterday, seeking a declaration that the provisions of the More Beds, Better Care Act, Bill 7, I'll refer to it as Bill 7, are invalid and of no force and effect because they offend the charter rights of patients under Section 7 and Section 15 of the Canadian Charter of Rights and Freedoms. And let me explain the legal issues that are at large in the application. The first, with respect to Section 7, which guarantees Canadians the right to life, liberty, and security of the person, and not to be deprived thereof, but in accordance with fundamental justice. So our evidence, as Natalie indicated, from really the leading experts on issues of hospital care and long-term care for the elderly patients who are the subject of this legislation. Our evidence is that by allowing for the discharge of those patients from the hospital, even when they are still in need of treatment in the hospital, or compelling them to accept admission to a long-term care home that cannot provide for their treatment or care or security or well-being, will increase for those patients their suffering and hasten their deaths. There couldn't be a more clear infringement of the first part of the Section 7 test that guarantees the right to life, liberty, and security of the person. You can still justify measures like that. Probably most Canadians would be surprised to learn if somehow those deprivations were made in a manner that accords with the principles of fundamental justice. But they don't under Bill 7, because the right of patients to consent to where they live, the fundamental right of all Canadians to determine whether or what health care they're going to receive, those rights are infringed by Bill 7. And the people that are subject to these deprivations have no right to review the decisions that are made that put them in this predicament or to appeal from those decisions. Those processes are fundamentally at odds with the principles of fundamental justice, and so the breach of Section 7, the right to life, liberty, and security of the person, I think is clearly made out in these circumstances. We have also sought a declaration that the bill is invalid and of no force and effect because it offends the rights to equality under Section 15 of the Charter. What we have here is a particular cohort of hospital patients. They're old. The overwhelming majority of them are over 65. Many of them are over 85. They are being deprived of rights that every other hospital patient and every other resident in Ontario, for that matter, has, to consent to where they live, to consent to the treatment and care they're going to receive, to actually receive hospital care when they're in need of treatment in the hospital. They alone are being singled out to be deprived of those rights simply because they're old and ill and require care. Again, we feel the breach of Section 15 is clear and patent under Bill 7. So, of course, it's up to the judge, but certainly our contention is that there can be little doubt that Bill 7 infringes both charter rights. There's still an opportunity for government to get out a jail card. That's Section 1 of the Charter, which allows governments to justify measures that deprive Canadians of their rights under the Charter if there is a legitimate and good reason in a free and democratic society that warrants those deprivations. And our contention is that that certainly isn't the case in respect of Bill 7 for several reasons. The first is that the bill, despite its title, won't create more beds and certainly won't provide anyone with better care, and in fact will deprive elderly and ill patients of the care they would otherwise have in the hospital. So at first blush, there's simply no connection between the title of the statute, its ostensible purpose, and what it will do. But beyond that, there are government policies in place. Jane has alluded to one of them, of keeping everybody in the hospital on a crisis list and allowing them to trump the crisis status of people in the community that may actually be more in need of care than people in the hospital, means that basically the only route to admission to a long-term care home is through the hospital. So you're stuck in the community, you're on the crisis list, you're desperately in need of care, you can't get in because you're too low on the totem pole, and your doctor says to you, if it's that bad, go to Emerge and get yourself admitted because that's the only way you're going to get into a long-term care home. So that policy actually drives people into the hospital. So does the policy of moving ALC patients into long-term care homes that can't care for them. And what happens then is that they get returned to hospital whenever something goes wrong for them in the home, often making several round trips. So you've got government policies that are working very much at odds with the purported purpose of the statute, which is to free up hospital beds. And the last reason I think that there's no plausible Section 1 justification for what the government's doing is this notion that the bill is necessary because somehow these elderly and ill patients are selfish and don't care that other people may need beds in hospitals, that they're actually bed blockers. It's not a term that the government's used, but it's certainly a term that has appeared in the media. They simply do not exist. Our evidence from experts that deal with these people day in and day out say, well, they may have heard rumors that people like that are somehow in the system somewhere, but they've never encountered them. And what our geriatricians and palliative care doctors tell us is, yes, there are people who have a preference for certain homes because those are the homes that fit with their cultural inclinations or because those homes have a record of actually providing decent care. And the lists are long. And when they're talked to in a compassionate way by physicians who persuade patients and families that really moving into a long-term care home, but that may not be their priority, is still in their best interest. Virtually all patients agree. So there is this notion that somehow people who are really the victims of the shortcomings of a healthcare system are now kind of scapegoated as the cause of those shortcomings in a healthcare system that doesn't meet the need of all Canadians to care in a timely way. We have a very successful healthcare system. I think there are tens of thousands of people in Ontario who will see a doctor or be in a hospital today, be very happy with the care and the services they provide. But there are problems. We all know there are problems. But the people that, old and ill people who probably need care more than anybody else, they've invested in public health care all their lives, they've paid their taxes, now they need care, are somehow now have to suffer the opprobrium of being selfish and inconsiderate bed blockers. It's just terrible, terrible characterization. I practiced public interest law for many years. I've dealt with all manner of ill conduct by private actors and public actors. I've dealt with unconstitutional issues that governments have promoted, like voter suppression by the Harper government, and ill-conceived strategies of basically betraying the public trust. Selling Hydro One was a case that I was involved in, but I've never encountered a statute that is as gratuitous, as cruel, and as visiting on its victims such immediate harm and often fatal harm. It'll be a year or more before our case is heard by a judge. I'd like to invite the Government of Ontario to suspend the application of this terrible law until the matter can be heard in court, if it's not willing to rescind the statute altogether. I think when the government has a chance to review the evidence that we've adduced in this proceeding, it might think twice of the wisdom of a policy which really is unwarranted and exacts a terrible toll on the oldest and most vulnerable members of our society. Thank you.
Thank you, Stephen. There are just 3 myths that I just want to make sure we have clear before we open it up. One is that the majority of alternate level of care patients, ALC patients, are waiting for long-term care. In the stories, in the media stories in the fall, there were all kinds of numbers floated out as to the number of people that would be blocking beds in hospitals waiting for long-term care. Some stories took the entire alternate level of care numbers for Ontario. Some took numbers that were far higher than the total number of alternate level of care patients in Ontario. Just to be clear, anyone who claims that all ALC patients are waiting for long-term care is making a false claim. The minority of ALC patients are waiting for long-term care. A whole range of ALC patients are waiting for rehabilitation in a hospital, inpatient rehabilitation, inpatient services such as complex continuing care or other types of hospital beds, palliative care. Some are waiting for home and community care, although home care patients are usually discharged to wait at home for home care. So it is the minority of ALC patients, and some of those numbers are just patently false. The second is that people would only temporarily be moved to these homes and then they would make it to a home of their choice. The fact is that, as Jane said, once they're out of the hospital, they're in a long-term care home, they are no longer the top of the crisis list and will not likely ever make it out of that home. That's where they'll die. And the third is that this will clear out hospital beds. And as Stephen described, of course, if all the hospital patients are crisis patients moved into long-term care, they take all the spaces. There is no space for anyone else. The only route then in is through hospital, and that's happening already. So, and thank you very much for that. Okay, any questions?
Sure. I'm Liam Casey with the Canadian Press. I don't think we've ever met personally.
We've never met personally, but we've spoken, absolutely.
Nice to meet you.
Nice to finally meet you.
Do you know sort of, I know you're hearing from a bunch of patients, do you know, say, how many have actually kind of refused, you know, the placement coordinators?
So they're actually paying $400 a day for their beds?
Either paying $400 or have refused, and then the placement coordinator has then gone on to have to accept, like, on their behalf. Do you have a rough idea?
Yeah.
I think I have an answer and you have an answer.
I'll just say that you know what we're hearing more of is that the threats of the $400 are people are just really caving and that they're being very afraid. You know, the government's not keeping those stats or giving them to me. So, you know, so it's hard to tell because what you're dealing with is a family in crisis where somebody's had a, you know, something crisis has happened, they end up in the hospital and they're told these things and they know that there's these laws and they're just afraid. They're like, I can't afford $400 a day. And therefore they're sort of going and doing whatever they're told because they know that it's going to happen anyway. And so it's kind of hard to tell. Most of the people that call us are very afraid and are sort of bending because they just don't know what else to do.
So we don't have any numbers.
Mm-hmm.
We have had people, couple now, who've died before they were forced out into the home, not of their choice. That's how in the hospital, they were trying to force them out to long-term care homes that they didn't want to go to, and they died. 2 of them so far that we know of. So just to, like, they're so vulnerable. And so, no, I don't know anyone who's paid or anyone who's refused. And, you know, in the end, they all end up going to where they don't want to go.
Yeah.
Or they die.
Yeah, and the other thing too is that it's you're also getting that pressure on people where, you know, maybe the person has like a mental health history. They may have, or they may be, you know, having because a lot of dementias, you might have some violence involved in that. And they're applying to homes, and the homes are turning them down, and the hospitals are threatening them and saying, "Well, if you don't, you know, pick homes," but we've chosen these homes, and they're all turning us down. I don't know what you want us to do, and they're threatening them. And you know, the only homes, I mean, sure, they could probably find a home to accept them that has available beds, but those aren't going to be the homes that are going to be able to care for that person. The good homes are saying we can't do it.
Is that sort of power imbalance, you know, in that moment, is that kind of at the heart of how their informed consent is being violated?
Well, there's sort of 2 ways that the informed consent's being violated. So first of all, yes, that's the power balance. But second of all, the legislation just says we're not going to, you don't have to have informed consent. We can just do any of this process and give anything, and we're just doing away with it. So there's those 2 parts.
Okay. And that's like in terms of like the private, the violation of privacy in that sort of same sort of charter violation.
But you don't have to say it.
Because the homes will actually just, like, they'll send you the whole kind of medical file to, or the hospitals to the homes? Is that, like, what kind of information is
The
this?
applications are pretty, they're pretty detailed. So there's what they call the RIMDS, which is a series of questions, and it's everything, you know, toileting, bathing, medications, there's behaviorals. So, you know, have you sworn at anybody? Do you hit anybody? You know, all this sort of thing. Medical documents. So they're not sending the hospital file per se, but it's a lot of information that's going, and very personal information.
Like including your like mental health
Yeah.
status, the drugs that you're on, if you have addictions, if you have, you know, abuse in your history, or, you know, like all behaviors. I mean, a lot of personal health information that just no other patient would be subject to that being sent to people without their consent, to an array of for-profit and not-for-profit long-term care providers without their consent, or other entities. I mean, it is shocking, really, when you get down to it. And then I think the power imbalance is very, very real. These are people who are in crisis. I mean, they're in crisis in the hospital, and then they're in crisis trying to figure out what to do about their loved one who is in precarious health at the end of their life. And they're desperate. I mean, mostly they call, they're crying. Mostly the person has dementia and a whole bunch of other comorbidities, and they're in very fragile health status, and they're grieving. The families are grieving at the same time. It's the worst thing. It really is awful to hear and see them then being forced. You know, for example, we had one person in Ajax, at the Ajax Hospital, and she was going to be forced possibly into Orchard Villa. She knew the home. She never wanted to go there. Who would want to go there? You know, it has one of the worst records in the province, has a terrible history of noncompliance. People died of, you know, dehydration, the families say, and starvation there. And so grandma, in this case, did not want to go there for a good reason, and yet was being forced there. And it was the subject of total trauma for their family that's what would happen to their loved one. That's what this bill does. And even to have their health information shared. And in one case, this is the former workplace of one of the patients. You know, it's not right. And Stephen just mentioned to me that we actually do have someone who paid, and so I should just...
Yeah, one of our witnesses is a wife of someone who's in a long-term care home now, but did pay the $400 a day charge for a few days.
Was it like a one-day?
I mean, I don't think that this information is, I'll be surprised if this information is gathered. We'll find out.
Like if
But
it's
I doubt that Home Community Support Services actually has this information. This kind of anecdotal account of, you know, how many patients were actually charged by hospitals and how many relented before. What the regulations require is that patients be informed by the placement coordinator that if they don't cooperate with the process of choosing a home they don't want to go to, they will be excluded entirely from the process and ultimately have to pay a $400 a day charge if they decline to go. So, and being excluded from the process means being excluded from determining who gets to see your personal health information. So it's just a terrible proposition. Why would you not relent? You'd have to be very determined to hang in there in the face of that kind of consequence if you don't agree. So I suspect most agree, as others have said.
And sorry, in the relief, I haven't finished reading the application yet, but the relief being sought, is it total kind of, you want the bill just completely rescinded? Is that the relief you guys are?
Sorry, I couldn't quite
The
hear that.
relief you guys are seeking, or the solution in the suit?
A declaration that the bill's invalid and of no force and effect. There are other provisions in the bill that really have nothing to do with ALC patients. So there seem to be housekeeping matters related to other aspects of the Long-Term Care Act. So we're not challenging the whole bill, just the main provisions that deal with this, which is the essence and pith and substance of the bill deals with these patients who are designated ALC. You know, and ALC is not, it's a term that isn't defined. There are no standards for determining who might need alternative level of care. Thousands of doctors and nurses in the province are entitled to make this call. So it's just a very, very arbitrary beginning to a process that is just very corrosive of the rights that people have protected and guaranteed under the Charter.
So, sorry, you said nurses and doctors can make that declaration or determination?
Any clinician, so it's doctors, it's nurses, there are some other people in the hospital setting that are also entitled to make that call, but no standards, no criteria, no guidance. You won't find any of that in the statute or in the regulations. So what our doctors tell us is that they often see patients who are designated ALC who are actually still in need of acute care. So misdiagnosed, or someone decides they're ALC on Monday, and a week from Monday, they've deteriorated. These are people who don't have long to live. About 20% of them, the evidence indicates, have 3 months or less to live. The others who find their way into a long-term care home, if they don't die in the hospital before they are actually admitted, join a population that has a life expectancy of 18.7 months. So these are people at the very end of their lives. It's a question of whether we just discard them, throw them away, blame them for needing health care services, or treat them with dignity and respect and compassion and care. That's the choice.
And I was going to say, one of the things, of course, that they're doing is they've got this 70-kilometer in the south and the 150-kilometer in the north. And one of the things that, those of us knew already, but apparently the government and everyone didn't seem to know until COVID hit, was how important having family, loved ones, friends, caregivers being able to come into the home and help. And so if you're moving the 85-year-old whose, spouse doesn't drive anymore to a place that doesn't have public transportation, and they're going to have to, rely on a friend or something, or maybe they only drive to the grocery store, so they can't drive 50 kilometers or 40 kilometers away. That person is now isolated.
Not fed.
And this system also doesn't have enough care. And so the other thing that we learned during COVID was how much care was being provided by these essential caregivers. And so those people aren't being able to go. And so can you imagine what it's like, and we see it all the time, is that, and that's one of the biggest issues is they're saying, they want to send, we live in Pickering and they want to send them to Beaverton, and I don't have a car and I don't drive anymore, and I will never see my spouse, and he will die alone without me, and he has dementia, and he doesn't understand why I'm not visiting. And what a horrible way to go on that, because that's where the beds are,
Thank you. Thank you very much.
Thank you.